Hi, this week on Title Talk, the topic is what's next for seller when buyer cancels during the inspection period for material property defects. Hi, I'm Jim Brown, Florida real estate attorney, founder at James Brown Law and New Path Title. So the issue is you've got a property and the buyer cancels during the inspection period for material property defects. They're justified in canceling. But what's next for the seller? What's the seller looking at? The rule comes from the case of Johnson v. Davis. It's a very old case. It's restated on line 250 of the contract, the Florida October FAR bar 2021 FAR bar. There's a outline related to this video. And so the test is this: a seller is under a duty to disclose when three things are present. A, the defect is known to the seller. B, the defect materially affects the value of the property. And C, reasonable inspections, the buyer will not discover the defect. There's a whole lot of other explanation we can go into talking about the third element, but let's just say in reasonable inspections, the buyer won't find the defect. The facts of this transaction were pretty simple. During the inspections, the buyer came through the property. There was a gigantic living room, a dining room, and in the dining room there was a big area rug, and the area rug went to the limits of the baseboard, and there was a giant 8-person table and chairs around the table. So the inspector comes through, they inspect the property. The dining area looks great, and they come back for the walkthrough. The table's gone, the chairs are gone, the area rug is gone, and there in fact is a giant crack in the floor and a bunch of loose tiles. The question of this title talk is, did the seller have a duty to disclose the break in the floor? And the answer is yes. Let's apply the Johnson test. So the seller had knowledge. They put the rug over the crack. The tiles were loose. They absolutely had knowledge. And the crack was, I saw pictures. It was hideous. The repair was a defect that would cost several $1,000s to repair, so it materially affected value. And I believe, and the only disputable element is, would a buyer discover this during reasonable inspections? And they call it latent and patent defects in the rule, but let's just say reasonable inspections for the purpose of evaluating the transaction. So the seller had a duty to disclose. I think we'd all agree. Materially affected value, seller had knowledge, and it wouldn't be discovered during reasonable inspections. The bigger problem is, and the topic I really want to dive into in this title talk is, what's the seller's next step and what's the agent's next step? So the saga in this transaction continued, and the seller tells the realtor, go get a tile guy and let's re-adhere the tiles and let's put the rug back over it and let's sell the property. And that's when the realtor called me and said, what do I do? And the answer is easy. I would tell the seller, look at the contract, look at line 250, and tell the seller they have three options now that the seller has knowledge in writing. They can either A, fix the property for the buyer and credit them at closing, which is what I like better because they have knowledge and they're going to have this problem in the future, so they might as well deal with it with this buyer. Or don't close with this buyer and disclose the defect in writing to future buyers because they have knowledge and it's in writing. If the seller insists on having you fix it and not disclosing, then you tell them, C, find another realtor because you can't breach your professional obligation. And if the buyer deposes you or serves discovery on you in future transactions and litigation because they've discovered the crack, then you're going to be under a duty under oath to tell the truth. So those three options usually get your seller doing the right thing. Read line 250 and tell them they can either fix it for this buyer because they're going to have to do it for this buyer or future buyers, or credit them, which is what I like better, or plan on disclosing the defect to future buyers. And if they tell you they insist on you fixing it, tell them to find another realtor and that you'll have to disclose what you know if there's ever future litigation. Thanks for another episode of Title Talk. I hope I've given you guys some more tools to get you to the closing table a little smoother. Always, if you have any questions, call me, text me. and I'll get right back to you. And don't forget to like and subscribe. Until next time.